Travis Wayne Goodsell. I finished the second draft, and I'm hearing on Nicole Wallace's show today, right now, about how Trump knew that this virus was a bad one, and yet he's done what he's done. Wait till you get a load of this lawsuit. Okay, so this is the main body portion. So the name of the defendant, Corporation of the President of the Church of Jesus Christ of Latter-day Saints et al., is a corporation of Salt Lake City, Utah. Corporate structure, CEO, also called President of the Church. First Presidency contains the CEO and 2 counselors. Board of Directors, also called Quorum of 12 Apostles, with a President of the Quorum. Presiding Bishopric. General Quorum of 70 with 7 presidents. Other offices in the corporation and in the religion are held by Mormons called members in the sense of chattel, having no say in the operations of the corporation. Succession of the CEO was established in their 1923 Articles of Incorporation, in which the President of the Quorum of the 12 automatically succeeds. See attached defendants administration chart with the American Crime Organization chart. I have a list of stuff to make sure I add those. As a corporation and the dominant religion of the state of Utah, their influence and control are vast, as Mormons and Utahns are subject to the defendant's dominion. Mormons therefore act as soldiers for the defendant, and Utahns are extorted as associates for the defendant, either willingly or unwillingly. As such, there were soldiers and associates of the defendant who acted under the authority or color of federal, state, and local law. Nature of the case. The plaintiff has filed a previous complaint against the same defendant, 219 CV 00711 CW, also under RICO conspiracy for actions by the defendant that began in 2008. The plaintiff filed a state petition for a redress of grievances against the defendant. The state of Utah refused to accept the plaintiff's complaint and countersued on behalf of the defendant, with the intent to disappear the plaintiff in the state hospital without ever going to trial. Dr. Cohn was the evaluating psychologist who manufactured a history of mental illness for the plaintiff, and the plaintiff was incarcerated for 6 years. The plaintiff later learned the defendant had been paying Dr. Cohn. Upon returning to society, the plaintiff was discharged from his mental health care provider, Valley Behavioral Health, and was moved to independent living housing as an independent individual. While still on Social Security disability, with a forced payee service, GCS, Guardian and Conservatorial Services, as Valley Behavioral Health refused to notify Social Security that the plaintiff can be his own payee. In 2018, the landlord, Valley Behavioral Health, started getting paid differently from Optum and desired to turn the plaintiff's residence into assisted living type 2, requiring the plaintiff to return to Valley Behavioral Health as a client and resume drugging, which almost took the life of the plaintiff in 2015. The plaintiff refused, and Valley Behavioral Health sent wave after wave of caseworkers to threaten the plaintiff and to force his return to assisted living. Finally, in 2019, the West Valley City Police Department arranged for the plaintiff to believe he was independent, but keep Percy James Pearson as an assisted living caseworker in the building's office. Soon thereafter, the plaintiff's air unit caused severe breathing problems for the plaintiff as mold had built up from property management's negligence in regular maintenance. The brand new property manager refused to fix the air unit for the whole summer and into the fall, when the plaintiff's lease was up for renewal. The air unit itself was not replaced until earlier this year in 2020, when a fan blade broke off. but mold spores remaining, causing confusion for the plaintiff as to whether or not he is having an allergy attack or symptoms of coronavirus. The problems encountered for the plaintiff by the landlord and property manager are a direct consequence of Dr. Cohn's manufactured history of mental illness of the plaintiff, and so the plaintiff was forced to file a complaint in the federal courts as a pro se litigant under informa pauperis, as no other agency would do their job to assist the plaintiff. The plaintiff had caught the defendant paying Dr. Cohn, and after informing Judge First on 1 November 2019's hearing to dismiss the plaintiff's complaint, the plaintiff was granted to amend his complaint. The defendant found out and then got caught trying to cover up their payments to Dr. Cohn. The plaintiff would eventually have his complaint dismissed with prejudice, despite lawfully winning, as everyone involved for this one case either forgot how to do their jobs or were purposely negligent. Knowing the identity of the defendant, it is obvious the answer is the latter. The plaintiff has since learned that the judges and courts tampering in the plaintiff's complaint resulted in his ability to file proper appeals or judicial complaints with the 10th Circuit Court in Colorado, and therefore files this petition for a redress of grievances. Cause of action, count 1. 18 U.S.C. 1512. This is tampering with a federal case or investigation. Judge Clark Waddups was assigned to the plaintiff's complaint filed 30th September 2019, despite his affiliation with the defendant and the temple loyalty oaths required over loyalty to the United States, the Constitution, and to the federal court. He refused to recuse himself, even after the plaintiff motioned for his recusal. He then went on to assign Judge First, who had just been terminated from the bench and had been recused of all her cases, including another case against the defendant. Count 2, same USC code. Judge Evelyn First had been terminated as a magistrate judge and recused from all her cases before being assigned by Judge Waddups to the plaintiff's complaint, filed 30th September 2019. She held a hearing on 1 November 2019 to dismiss the plaintiff's complaint. After granting the plaintiff to amend his complaint, Judge First remained silent the rest of her term on the bench. She did not order summons requiring the plaintiff to file a waiver of summons. She did not order the defendant to pay the $2. I want my $2, for not responding to the waiver of summons. And she did not report and recommend final judgment on behalf of the plaintiff for default of the defendant. Count 3, same claim. Clerks of the court ordered the plaintiff to wait for Judge First to order the service of the complaint, which order never came. The clerks of the court failed to post the plaintiff's counter-reply, and the defendant's failure to return the waiver of summons, and their default for not filing a proper motion upon being properly served. Count 4, same complaint. Upon Judge First's last day on the bench, Judge Waddups assigned the brand new hired magistrate judge Daphne Oberg to the plaintiff's complaint. Because the clerks of the court did not file the plaintiff's counter-reply, Judge Oberg wrongfully assumed the plaintiff filed in default, failing to recognize there was no service filed on the defendant. Judge Oberg went on a denial of the plaintiff's motions, going back to do the work that Judge First failed to do. Judge Oberg refused to acknowledge these violations of the law and court process and reported and recommended on behalf of the defendant for dismissal with prejudice. Upon Judge Oberg's submission of her report and recommendation, she was immediately rewarded with other new assignments. Count 5, same complaint. Defense counsel never returned the waiver of summons to the plaintiff so that it could be filed with the court. Instead, the defendant was involved in stock market sell-off. In the stock market sell-off in March, was caught covering up payments to Dr. Cohn and intentionally hesitating to shut down their business and religious practice, places of worship, in direct defiance of all warnings from health professionals, as the defendant's CEO is himself a world-renowned medical doctor and surgeon, resulting in the contribution to the escalation and prolonging of the coronavirus pandemic. Then, as the virus was still escalating in Utah, the CEO began reopening of businesses and religious places of worship. Count 6, same complaint. Property manager Samantha Hansen for Danville Development, a partner with landlord Valley Behavioral Health, both of whom were listed in the plaintiff's complaint as co-conspirators. After the plaintiff had served the defense counsel with the waiver of summons, issued the first of 2 eviction notices to the plaintiff on Friday the 13th of March 2020. Friday the 13th. The second eviction notice was presented to the plaintiff after Judge Oberg's report and recommendation against the plaintiff. Neither the property management, nor the landlord were properly licensed for the past year. The landlord is demonstrating a persistent pattern of lawless abuse as a healthcare provider by seeking to cover up their failure to renew their healthcare license for the previous year by renewing it after being informed by the plaintiff of their illegal actions, demonstrating their determination to break the law to turn the independent living facility of the plaintiff into assisted living type 2. The landlord is also collecting rent as a still unlicensed renter, and as the pattern shows, they will lay in wait to attack the plaintiff in the future as his lease is up in November 2020. Count 7, same claim. CEO Russell M. Nelson, after the plaintiff filed notification to Judge Waddups. I did inform you this is RICO, right? 18 U.S.C. 1512. I hope I did. Just wondering if I even did that. Russell M. Nelson, CEO Russell M. Nelson, after the plaintiff filed notification to Judge Waddups about the defendant's temple loyalty oath changes Nelson made to the law of chastity, allowing for the return of polygamy, for which the defendant was disincorporated under the Edmunds-Tucker Act, replied with a public statement that the temple loyalty oaths were changed again, though the public has not been informed if the allowance for polygamy was removed. The plaintiff's complaint had included 2 counts of bigamy after the plaintiff filed notification to Judge Waddups about the defendant's affiliation with the Illuminati, the first United States domestic terrorist organization. With the submission... is this the right place for this? I think so. Yeah, because I did notify him about the inverted pentagram, so yeah. After the plaintiff, this is another, pay attention, there's more to come. After the plaintiff filed notification to Judge Waddups about the defendant's affiliation with the Illuminati, the first United States terrorist organization, the first terrorist organization against the United States. After the plaintiff filed notification to Judge Waddups about the defendant's affiliation with the Illuminati, the first terrorist organization against the United States, with the submission of the inverted pentagram on the keystone of the arch of the door of the Salt Lake Temple, and on the foundation stone of the Ark of the Seagull Gate at Temple Square on State Street, the defendant, 2 weeks later, released a statement that Jeffrey R. Holland of the Quorum of the 12 had taken ill immediately after his Monday morning interview and his notification by defense counsel of the plaintiff's notification. Count 8, again, RICO. I didn't make that clear in the beginning, or I messed up with the wrong. Utah Governor Gary Herbert, a known Mormon, blatantly disregarded all medical professional warnings by hesitating to shut down the state and instead adhered to the national executive's misinformation and disinformation, causing escalation of the coronavirus with controlled daily testing to justify controlled daily and faulty testing to justify the number of new cases rather than percentages, to reopen too early when the escalation was worse than when Utah was finally shut down. Individuals in key positions were fired so that adherence to the national executive for herd immunity could continue, and as Governor Herbert himself declared at his weekly briefings, it was his intention to get Mormons back to church. Governor Herbert's actions have resulted in not only an escalation of the virus, but an indefinite prolonging of the virus. Various local Utah news stations reported around 1,000 Utah students who were quarantined, but those numbers were never reported on the state's coronavirus reporting, which would have made the week of 30 August 2020 to 5th September 2020 at 17.25%, which is well into the red zone for the state of Utah. Because of Governor Herbert's manipulation of the virus stats and fraudulent claims that Utah is in yellow and green, Utahns and Mormons are protesting the mandate to wear masks, claiming if there is no more threat from the virus, then the wearing of masks is no longer necessary. Governor Herbert has warned of the consequences of not adhering to medical professionals. Was warned, but persisted with actions of a pattern of lawless abuse that has cost Utahns their lives just to tamper with the plaintiff's case to protect the defendant. Count 9, is this correct? I did a copy and paste, so there may be some 7, 6, 5, good. So count 9, 18 USC 113B, terrorism. The founder of the Church of Jesus Christ of Latter-day Saints, Joseph Smith, started the organization in response to the first terrorist threat to the new United States of America by the Illuminati, formed by Johann Adam Weishaupt on 1 May 1776. Their symbol was the falling star or inverted pentagram for Lucifer, the Latin word for the planet Venus, in the Latin Vulgate translation of the Bible for use in Isaiah 14:12, which is also used in the Book of Mormon of the Founder. The keystone of the LDS Church history is the place of Canandaigua, New York, with the connection of Captain William Morgan, Joseph Smith Sr., as the Master Mason of the York Rite Freemason Lodge, and Heber C. Kimball, whose Wikipedia page article on his masonry is completely contrary to truth. From that 1826 American history event called the Anti-Mason Movement came the Book of Mormon of the Smiths organization, which gives the latter-day date for when the Illuminati would strike again in America. The Doctrine and Covenants, section 45, verse 31, exposes the weapon to be used by the Illuminati. The defendant originates from the terrorist Illuminati, as they murdered the founder and his brother, took over leadership claiming true succession, but using the Illuminati symbols as signs to other Illuminati on the Nauvoo Temple, the Salt Lake and Logan Temples, and on the Seagull Gate Arch on State Street at Temple Square. The defendant has been a sleeper cell all these decades. The defendant's violation of health professionals' warnings is the fulfillment of this premeditated, planned viral attack on the United States of America, as Governor Herbert is also complicit. Count 10. Need to make that darker, I believe. Okay. 18 USC 115. Treason, sedition, and subversive activities. By using a viral weapon, the defendant and their soldiers and associates as Native American citizens have committed the act of treason with the intention to destroy America and its Constitution and restore a monarchy over a conquered nation. Injury. The lawless actions committed by the defendant and their co-conspirators place the life, liberty, and property of the plaintiff in great jeopardy. The dismissal of the previous complaint keeps the fraudulent identification of mentally disabled upon the plaintiff, as his landlord attempted to evict the plaintiff in retaliation during a viral pandemic. The defendant and their soldiers and associates will never leave the plaintiff alone, as was why a petition for grievances was necessary. The defendant is in financial ruin, all because the defendant is threatened by the plaintiff's support for the founder, Joseph Smith Jr., as a translator, as the defendant is fraudulently representing themselves as the true successors, when in reality are a branch of the original terrorist group against the United States. The plaintiff's life is in great jeopardy for exposing the defendant, as the plaintiff struggles with censorship and attacks, even death threats online. And at his residence. The influence and control of the defendant is worldwide, and thus the plaintiff will be retaliated against for the rest of his life if the defendant is allowed to continue to exist. This is a new filing based upon actions committed against the plaintiff for a previous filing. As such, this is the formal appropriate relief sought. Request for relief. As no amount of money damages can compensate for the injury done to the plaintiff, the organization does not belong to the defendant, as they obtained it fraudulently. The plaintiff therefore seeks a vesting of title of the defendant's corporation to the plaintiff, as would best secure the rights, life, liberty, and property of the plaintiff. A RICO, terrorist and treason criminal case would need to be processed to ensure better security and safety in vesting title to the plaintiff. And then signed on yesterday, because I thought I was going to have it done yesterday until the end of the world happened. And so, let's see, I need this, I need this, I don't need any of this. This is all old material. Alrighty, so then I'll print this out and scan it back in as a PDF, as all one document, and submit it to the courts. And we're almost at 3 p.m. You'll be seeing this after I file, and we'll go from there.